My name is Melissa Murray, and I am a professor of law at New York University School of Law, where I teach constitutional law, family law, and reproductive rights and justice, and serve as the faculty co-director of the Birnbaum Women's Leadership Network. Prior to my appointment at New York University, I was the Alexander F. and May T. Morrison Professor of Law at the University of California, Berkeley, where I taught for 12 years, served as faculty director of the Berkeley Center on Reproductive Rights and Justice, and served as interim dean of the law school. Like Judge Kavanaugh, I too am a graduate of Yale Law School. Over the course of these hearings, much has been made of Judge Kavanaugh's warmth and kindness towards his clerks and those in his community. These accounts resonate with me, as Judge Kavanaugh and I have traveled in similar professional circles over the years. In fact, I too have had lunch with him, and I can attest to his friendliness and charming demeanor. But this nomination is not about whom I would befriend or with whom I would have lunch. It is not about how Brett Kavanaugh treats a handful of women from elite institutions. It is about real people on the ground, people like the women to my right and the people they represent, who will not have lunch with Judge Kavanaugh, who will not meet with Judge Kavanaugh, but who will nonetheless depend on Judge Kavanaugh to protect their constitutional rights to make decisions about their lives. As you've heard from women like Alicia Baker and Liz Weintraub, confirming Judge Kavanaugh to the Supreme Court would threaten people's ability to make fundamental personal decisions, including deciding whether to have an abortion. Reproductive rights are under serious threat in this country. What we have seen over the last 2 decades is a concerted strategy that would dismantle Roe v. Wade piecemeal, not in one fell swoop, but rather through a death by 1,000 cuts. This nomination is the culmination of that decades-long effort to destroy Roe v. Wade incrementally, without necessarily formally overruling it. The Supreme Court stands as a bulwark against this assault on reproductive freedom. Just 2 years ago, in Whole Women's Health versus Hellerstedt, Justice Kennedy joined a majority to reaffirm the undue burden standard first articulated in Planned Parenthood versus Casey, thereby reaffirming the court's commitment to protecting reproductive rights. But Judge Kavanaugh's nomination to replace Justice Kennedy imperils the court's ability to continue to hold the line on reproductive freedom. In Garza versus Hargan, the only abortion case to come before him, Judge Kavanaugh voted to block a young immigrant woman from receiving abortion care and insisted that she remain pregnant against her wishes, weeks after she had made her decision and after she had completed all of the state-imposed requirements. Although he claimed to follow Supreme Court precedent in Garza, Judge Kavanaugh's opinions evinced a crabbed and skeptical view of these precedents, a view that is completely out of step with the High Court's own view of those cases. Despite his claims during these confirmation hearings that he was respecting Supreme Court precedent on minors and abortion, in fact, his dissent shows the opposite. He ignored the Supreme Court's holding in 1979's Bellotti versus Baird that allows minors to complete a confidential judicial bypass in lieu of parental or guardian consent. Jane Doe had already met the Texas requirement of a judicial bypass by the time her case came before Judge Kavanaugh, so further delay to seek a sponsor was wholly unwarranted. Further, Judge Kavanaugh did not explain how the government's flat prohibition wholly preventing Jane Doe from accessing abortion failed to constitute an undue burden under Casey or a pre-viability ban under Roe. Nor did he weigh the potential harms to Jane Doe stemming from a further delay against the purported benefits of that delay, as is required by Whole Women's Health. Judge Kavanaugh's record in Garza suggests that rather than respecting precedent, he will undermine or ignore it. And in so doing, he will provide the necessary fifth vote that would utterly eviscerate the right to abortion. During these hearings, when asked by you, Senator Feinstein, whether he agreed with the statement that a woman's right to control her reproductive life impacts her ability to participate equally in the economic and social life of the nation, Judge Kavanaugh's reply was not, "I agree." Instead, he said, "I understand the importance of the precedent set forth in Roe versus Wade." We have seen this before. In 2005, then Judge Roberts came before this committee and stated that Roe is the settled law of the land during his own confirmation process. Despite this earnest declaration, as a justice, he voted to uphold a statutory scheme that would have shuttered 75% of the clinics in Texas, If this is what it looks like to respect precedent and treat Roe as settled law, then these are empty promises. Since 2011, politicians have passed over 400 new laws in 33 states across the nation that shame, pressure, and punish women who decide to have an abortion. Some of these laws would ban abortion as early as 6 weeks before a woman may even know that she is pregnant. Others would require doctors to convey a falsehood to patients, telling them that abortion leads to breast cancer. The point of these restrictions is to make it difficult, costly, and in some cases impossible for women to obtain an abortion. And as such, these restrictions impede women's ability to participate equally in the social and economic life of the nation. And these restrictions are especially detrimental to young women, women struggling to make ends meet, women of color, immigrant women, rural women, and women who have already had children. In practice, these restrictions mean that Roe is merely a hollow promise and not a reality for many women. To be clear, Roe versus Wade is not a decision invented by activist judges. It is part of a century's worth of jurisprudence that protects an entire constellation of rights, rights relating to family, marriage, parenthood, contraception, personal autonomy, and intimate life. A vote against Roe is whether to overrule it as a formal matter or gut it through